And where's Alvin Tan?
Mr. Speaker, sir, I thank Mr. Louis Ng and Mr. James Lim for their views on the bill. I will first address specific questions raised on the bill before tackling the broader questions on the relevance of business trusts, structure, and the trust foundations in the philanthropy landscape. But I wanted to also say that I think for the purposes of this amendment bill, that we focus very much on the core of what we're trying to do, which is to enhance transparency and strengthen governance of business trusts. And I think for many other topics, I think we can leave that on another day. On the bill, both Mr. Louis Ng and Mr. James Lim raised questions on provisions that will seek alignment to align the BTA with the regulatory regime for companies. Mr. James Lim asked about the appropriateness of replicating the Companies Act's provisions in the BTA, as well as whether we need to strengthen the regulatory regime for business trusts relative to the regulatory regime for REITs. Now, business trusts, as a member had noted, is also meant to be an alternative business structure to companies. Hence, the regulatory regime for business trusts is modeled after that of companies. Well, similar to the Companies Act, the intention of the BTA is to set up requirements to protect, indeed, the fundamental rights of unit holders of this registered business trusts, and to set out the duties and accountability of the trustee managers and their directors. That's at the fundamental level. Now, and then on top of the requirements that were adapted from the Companies Act, MAS has also included relevant governance requirements from the REIT regime. Now, business trusts and REIT, of course, share a lot of structural similarity. For example, both are externally managed, as I mentioned in my speech. MAS has also taken reference from applicable REIT rules when reviewing the BTA, especially in areas where the risks are similar. REIT rules, when reviewed, and for instance, actually, as MAS has in this bill, proposed that the removal threshold for trustee managers be aligned with that for REIT managers. So if you reference the requirements for REIT managers, MAS is also considering amending subsidiary legislation of the BTA to enhance independence requirements for directors of trustee managers. MAS will be consulting on the suite of proposed amendments to subsidiary legislation of the BTA in the coming months. Just a few points about the fiduciary role of the directors of trustee manager. Well, the directors of a trustee manager essentially performs the same fiduciary role as the directors of a company. Hence, we are trying to align BTA with the Companies Act. So the provisions allowing loans to be given to directors of companies are also relevant to the directors of trustee managers within the BTA. On whether vehicles are trying to get away with easier regulations as regards to the BT versus a REIT companies, BTs and REITs are both, and in fact all, subject to corporate governance requirements. Assets that do not fall neatly under a REIT structure can be included in a company structure. So it's important that we have these proper rules and consistent rules for both companies and BTs. And that's why, again, going back to the fundamentals, that's why we are aligning the BTA to the Companies Act. On Section 52, there's an existing provision that MAS may apply to a court to appoint a liquidator to wind up and thereafter deregister a defunct BT. The new Section 52B provides for any persons with reasonable cause that the BT should not be deregistered to object when MAS issues a notice of its intention to apply to court for liquidation. So the context of Section 52 is actually for defunct BT, but it's actually not for still functioning BTs, just to clarify that point, which is, I think, quite important. You also, the member, Professor James Lim, also mentioned about the distance between trustee managers, again, the BT, and unit holders or stakeholders. The trustee manager in this regard has to manage businesses and operations just in the same way as the board or the management of companies has to similarly consider the interests of key stakeholders in order for the business to be successful. So again, going back to it is really aligning both. On the distribution of REITs, I just want to clarify that REITs must distribute 90% of the income in order for them to enjoy tax transparency. In fact, REITs are required to distribute at least 90% of their distributable income to enjoy this tax transparency, where BTs do not enjoy any tax transparency and hence are not subject to a similar requirement. So there are differences between REITs as well as BTs, and that's why, although they are structurally similar, some of the provisions we have to regard them as separate as well. Let me see, maybe I address other points with regards to trusts and REITs. REITs are investment funds which are obviously subjected to investment guidelines and are intended to specifically hold income-producing properties. And business trusts are not investment funds. They are business structures which can hold a wide range of assets. You mentioned many of the 18 that you raised earlier on, so they do hold a wide range of assets. But they're not limited to real estate, although many that you raised appear to be linked to, but they can also operate active businesses. So both the two regulatory regimes cannot therefore be equalized. So what MAS has done is to draw the most appropriate provisions from both the Companies Act and also the REIT regimes to design a regulatory framework that addresses the needs of stakeholders in a business trust or BT. MAS will also regularly review the regulatory regime for business trusts and will make appropriate refinements to ensure that the regime remains robust and also meet the market needs as and when it's required. Mr. Louis Ng raised a few questions relating to loans by trustee managers to their directors for defending against proceedings or regulatory actions. Mr. Ng also asked about the difference in treatment between loans made to directors for defending against civil and criminal proceedings compared to loans to directors for defending against regulatory actions. In the case of loans for defending against civil and criminal proceedings, the bill requires specific terms to be placed on the loans, namely that the loan is to be repaid no later than 14 days of certain events occurring, such as if the director is convicted. However, similar loan repayment terms are not required to be included for defending against regulatory actions, consistent with the comparatively less severe nature of regulatory actions versus court proceedings. So the difference in treatment also follows from equivalent provisions in the Companies Act, and it also can be found in the UK Companies Act as well. Mr. Louis Ng also asked for clarification whether repayment will be required in situations not specified in the bill, such as if charges are withdrawn. Well, loans by their very nature are expected to be repaid according to the terms of the loan agreement, unless otherwise agreed with the lender. While the bill will not require trustee managers to include terms in their loan agreement for repayment of loans under circumstances other than those specified in the bill, trustee managers can still choose to include such terms as they deem appropriate. Now, for repayment terms that are required by the bill, Mr. Louis Ng further asks how these should apply when a loan was granted to the director to defend criminal or civil proceedings and a conviction or judgment against the director was only obtained for some but not all of the charges or heads of claims. Now, as the provision does not provide for apportionment, the general position is that the loan will need to be repaid according to the required terms as long as the director is convicted or judgment is made against the director and that the conviction or judgment is final. So the next set of questions Mr. Louis Ng raised relate to the transparency requirements for unlisted business trusts regarding their registrable controllers, or controllers for short. He asked what would constitute reasonable steps for the purpose of a trustee manager's discharge of their obligations to identify controllers of a BT or business trust. Now, MAS intends to issue guidelines on this, similar to the guidelines issued by ACRA under the Companies Act. Under ACRA's guidance, a company is regarded as having taken reasonable steps if it sends out a notice at least annually to each member and each director of the company, unless the person has already provided it with the requisite information. So Louis Ng further asked about the differing burdens placed on a controller versus a person who knows or ought to know the identity of a controller. Now, for brevity, I will refer to the latter as third parties. The bill requires both controllers and third parties to provide information to the trustee manager when served with a notice to do so. In addition, controllers are required to notify trustee managers of their particulars, such as the dates they became controllers of the BTs or business trusts. However, third parties are not under similar obligations to furnish information on a controller unless they have been asked to do so by the trustee managers. The differing requirements are intended to balance between requiring trustee managers to maintain a complete register of its controllers and the burden to third parties. The duty to notify the trustee manager of a controller's beneficial ownership of the business trust falls naturally on the controller himself, as he is the primary source of information about his own interests in the business trust. The same cannot be said for third parties, who are one step removed. Requiring a third party to provide the trustee manager with information on another person, the controller, without being asked to do so would impose an excessive burden on the third party. Nevertheless, where a third party is served a notice by the trustee manager to provide information on a controller, he would be clearly informed that the information required of him. He would therefore be obligated to provide the information in this situation. Mr. Speaker, sir, I will now address the broader questions raised by Mr. James Lim on the role played by business trusts and on the development of the trust and foundation landscape, and if there are any ways in which the government can foster a culture of philanthropy. Now, business trusts are by design suitable for businesses, as I mentioned in my earlier speech, that have high cash flows and also stable growth. They add to the array of many alternative structures for businesses to organize themselves in a manner that meets their operating and fundraising needs. As for Mr. James Lim's suggestions to support a culture of philanthropy, they extend quite beyond the scope of the BTA, as I mentioned earlier, but we'll be happy to take those questions as matters of further study where relevant. I'll also just mention that one of the strategies under MAS's Financial Services Industry Transformation Map, or ITM 2025, is to help to develop Singapore into Asia's Centre for Philanthropy, and MAS will provide support in line with this ITM, the Industry Transformation Map. In fact, last week, DPM Lawrence Wong announced a number of measures that we are studying, including reviewing our tax incentive structures and schemes to see how we can encourage family offices to do more philanthropic giving and to support the local philanthropic ecosystem by structuring their giving through local charities and also non-profit entities. Just on another point by Associate Professor James Lim on taking a more interventionist approach to direct high net worth wealth to fund specific causes that are aligned with Singapore's interest, the approach thus far has been to enhance just the overall ecosystem to encourage high net worth individuals to conduct their giving activities in Singapore, effectively just to build the culture of philanthropy, and also when these offices and these structures come to Singapore, encourage them to give locally as well. It's also to help them to find ways in which to give to local causes as they gain familiarity over time with what is required in the landscape. So we've so far steered away from dictating the causes that high net worth individuals should give to an industry. So we just don't want to be that prescriptive in that regard as we start to build up this ecosystem. So, Mr. Speaker, let me conclude by reiterating the benefits that we seek to bring with this set of amendments. Now, these amendments will bring the BTA in alignment with the regulatory regime for companies upon which the regulatory regime for business trusts is based. It will also strengthen the corporate governance safeguards of business trusts. I also wanted just a final point to share that this is not very unique to Singapore. In fact, apart from Singapore, there are a few other jurisdictions where business trusts are also used as corporate vehicles. Australia, Hong Kong, Canada have business vehicles quite similar to our BTs. But of course, our own business trust regime has its own legal framework with very clear rules that are specifically tailored to the features of our business trusts. In fact, it was developed to be as close to a company as possible, as they are intended to have alternative structure to companies so that they have that flexibility. For example, Malaysia's BT regime, business trust regime, is also quite similar to that in Singapore. The other jurisdictions also have Australia, Hong Kong, BT, and Canada, for example, have different structures, but they are suited to their own regulatory. They have their own regulatory regimes suited to their own ecosystem. So, in short, by amending this bill, the bill will contribute towards a strong hopefully a robust and transparent regulatory framework for businesses and investors, and also support Singapore's business competitiveness. With that, Mr. Speaker, I beg to move.
Are there any clarifications? Question is that the bill be now read a second time. As many as of the opinion say aye. The contrary say no. I think the ayes have it. The ayes have it.
Business Trust Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
Question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 63 stand part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. MOS Alvin Tan.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Business Trust Amendment Bill. Item 4, Accountants Amendment Bill, second reading.
Order. I propose to take a break now. I suspend the sitting and will take the chair at 14:15 hours. Order. Order.